All right, guys, let's level set. The context of today's video is Section 5 of the Senate Banking Committee's Digital Asset Market Clarity Act. So Section 5 specifically refers to the critical anti-money laundering and surveillance amendments that they added. So this is ripe. So while the House version of the bill focused on whether an asset is a security or a commodity, the Senate's new version, which was released this week, added teeth that privacy advocates are calling the Patriot Act 2.0. So what does that mean? It means that they think there's language in the bill that says, hey, we're going to spy on your finances, pretty much. Okay, but let's take a no-nonsense news approach here, and then we're going to talk about what it all means and how pissed off we need to be. So the breakdown of Section 5. In the legislative draft currently causing the $97,000 price volatility in Bitcoin and the privacy coin pump, right? We've seen Monero shooting up. Section 5 specifically addresses illicit finance and intermediary responsibility. And here's what's in it. Number 1, a control test for DeFi. Section 5 creates a legal definition for control. If a person or DAO has the ability to unilaterally modify the smart contract code, they are no longer considered a decentralized protocol under the law. The result, they are reclassified as a financial institution. This means every developer with an administrative key or a governance token could be legally required to implement KYC, which is Know Your Customer, or face criminal charges. Number 2, amendments to the Bank Secrecy Act. This is the surveillance part, guys. Section 5 amends Section 311 of the Bank Secrecy Act to specifically include digital assets. So what does that mean for the power it gives them? It gives the Treasury Department the authority to designate any specific crypto protocol, geographic region, or wallet type as, quote, primary money laundering concern. So once designated, U.S. exchanges and banks are prohibited from interacting with those wallets. This is the mechanism the government could use to debank or off-ramp users who self-custody wallets that haven't been verified. That's the scary part, guys, right? So there's technically possible. What they're saying here is that it is technically possible, okay? Depending on where your wallet is, what address it is, what protocol, whatever, right? The U.S. exchanges could be prohibited from interacting with that. Now, what does that mean? I'm not saying this is going to happen, but let's just say you've got some cold storage wallet and the wallet address is not verified or not part of, a verified exchange or whatnot. If that address is not whitelisted, you may not be able to transfer your tokens from your cold wallet into your Coinbase wallet, right? That is the scare and the language that's in this that could possibly happen. So real-time record keeping, that's number 3. Section 5 mandates that any registered digital asset intermediary must maintain records that are instantly accessible to the SEC and CFTC. So in the past, the government had to subpoena records. Under the Clarity Act, Section 5, the infrastructure is being built so that regulators have a real-time window into the flow of funds on regulated blockchains. So number 4, the Foreign Adversary Clause. Section 5 would explicitly target non-US protocols. It gives the president power to block any transaction involving a digital asset if it is determined to be, quote, controlled by a foreign adversary. So here's the catch. Because many decentralized protocols have global contributors, the government could theoretically use this to block a major DeFi platform simply because one of its developers lives in a hostile country. So this is why, guys, this is why we're seeing Monero hitting all-time highs today. Because investors are realizing that the clarity in the Clarity Act is actually transparency for the government. Okay, they want to watch. They want to see what's going on. And that's kind of the basis of Section 5. I don't know if any of this is actually going to come to fruition, right? Like will my LAPAL cold wallet addresses not be whitelisted in Coinbase? So if I want to ever transfer to Coinbase and turn it into USD and liquidate some assets, is that going to be blocked? According to this language, it could be. I'm not saying it's going to be, but it could be, right? Because if we go back up to that section in the bill in the proposed bill, right? It gives the Treasury Department the authority to designate any specific crypto protocol, geographic region, or wallet type as primary money laundering concern. So, can they tell how my wallet was created? Well, if I created it offline on Elipal and I'm using Coinbase to transfer it to my cold storage, right? So once banks and exchanges are prohibited from interacting with those wallets, how do I get my money back, right? How do I go back in there and unlock my wallet and get my stuff? So these are the things that we need to pay attention that are buried deep inside these hundreds and hundreds of page bills. Okay? So I'm not making this video to scare anybody. What I'm doing it for is so we know that we're begging for the Clarity Act, so because they've been pitting it against the SEC and the CFTC and what's a security and all this, when inside of it there's a lot of stuff in these 400 plus pages of the bill. In this section 5 specifically, anti-money laundering and surveillance is a big thing, and right away they'll position as like, oh, it's you need to be moving millions of dollars, or oh, they're not going to let until they do, right? Until they get these things in place, and years from now they'll be like, oh yeah, according to this rule we can, you know. So those are the things we need to just be aware of. Keep an eye out for the news and see if they say like, okay, yeah, we're going to enact this, and anything on cold storage, you're going to get flagged. You have to go to an exchange. And then what? Then they completely take over crypto. They completely take over DeFi. Cold storage goes away. And you have to be part of a big institution or risk not being able to free your assets. Okay? That's the type of thing we're going to be looking for. And we're going to keep following this, right? We need to dig in. We need to dig into the language of these bills so we know what the heck is actually going to be passed and what we're cheering for. We may be cheering for surveillance and frozen assets and not know it. So again, guys, I hope this helps. I don't want to be too negative on all of this because I want regulation and clarity, but at the same time, we want financial freedom and the ability to do what we want with our own money. So I hope this helps. Stay tuned for the next one.